Hey everybody, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to talk about the first steps you should take if you are designated as the executor or trustee of an estate. Before we get there, however, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, first of all, it's a logical step to first reach out to the attorney who helped draft the estate plan for your loved one who passed. Have a conversation with them so they can explain what was created and what the next steps are. See if you jive with that individual and their firm, and if you think it's a good fit, hire their services so that you have a quarterback throughout this process. Of course, if the attorney is retired or they've passed themselves, or maybe you just don't jive with them, do a little search online, find someone with decent Google reviews, and interview a couple more attorneys to find someone that'll work for you. You want to be comfortable in that relationship so they can guide you through it. Then a few things that are the responsibility of you as that fiduciary to make the initial steps sort of run smoothly is a notification to organizations such as Social Security, credit cards to cancel those so no fraudulent action is taking place, and maybe a life insurance company that may be existing for your deceased relative, so that continued maybe deposits or withdrawals, I should say, aren't being made for premium payments. Now, when you're working with this attorney, you're going to go through the process of collecting an inventory of the assets and everything owned by the person who passed at the date of death. It's important to have that picture so that you can report that to all of the beneficiaries. In addition, you're going to work with the attorney as a quarterback on figuring out, managing, maybe negotiating any debts and expenses that exist, including potential taxes. Now, the attorney should be there to support you through, of course, any court filings, tax preparation alongside an accountant, and any of the respective correspondence and conversations with the beneficiaries to make sure those processes all go smoothly from the beginning to the end. And just as a reminder, and we've mentioned this on several occasions in different videos, the probate or administrative process, even if it's just a trust administration, does typically take on average a minimum of 18 months. And that's because there's usually income tax returns that need to be filed the April following the passing and maybe beyond that. So be mindful of that. There is no rush. In fact, I find when folks are in a rush to get these processes done, that's when mistakes happen. You want to take a step back and a breather and let the counsel that you've entrusted help quarterback sort of the speed and the process and all the steps that you need to go through, because there are quite a few. Again, as a reminder, if you have any estate planning or probate questions, feel free to reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening, and if you found this information useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. And again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.